Hi, my name is Robert Chelle with Chelle Law, and my law firm assists nurse practitioners with employment contract issues. Today I'm going to talk about the components of a non-compete for a nurse practitioner. So, if you're a nurse practitioner and you're signing an employment agreement, or many times an independent contractor agreement, there will be what's called restrictive covenants in the contract. And so the normal restrictive covenants would be a non-disparagement clause, meaning you couldn't speak badly about the employer after the contract ends, a non-solicitation agreement, you can't actively solicit patients, employees, other providers for a period of time, and then lastly, there'll almost always be some kind of non-competition clause, which then prohibits the NP from working for a period of time within a specific geographic radius. Now, there are a handful of states where non-competes are completely unenforceable. So if you're going to sign an agreement, you need to check and see if you are working in one of those states. What I'm going to talk about today is for the people outside of that, in the states where they are enforceable. Now, every state has their own, kind of case law and or statute about non-competition clauses for healthcare providers. Most are not in the code, meaning there aren't specific laws about it. It's almost all done through case law, meaning people that have litigated, sued people, and then the courts have then made decisions about what is considered reasonable or not. But if a court is making a determination of what is reasonable or not for a non-compete, they're going to look into, all right, how much does it restrain the nurse practitioner from finding another job? Is it reasonable in length? Is it reasonable in geographic scope? Do they have other opportunities? Is it for their specific specialty? The court will kind of take all of that into account and then determine whether it's enforceable or not, or sometimes they'll even just lessen it to a certain degree. So let's talk about the kind of breakdown of the components of a non-compete for an NP. So first, how long it lasts. So most NP non-competes are usually somewhere between 12 to 24 months long. Obviously, you want to gear towards the shorter amount. It's pretty rare that you'll find a non-compete shorter than a year, but 1 year is a fairly standard amount, and that's what you're going to be aiming for. So if you see a non-compete for 3, 5 years, something crazy like that, that would very likely not be enforced, but you want to move towards the 12-month period. Second, the specific specialty. So what you want to do is if you are, working in a urology practice as an NP or dermatology or something like that, you don't want the non-compete to state you can't work as a nurse practitioner at all during the 12-month period. You want it to say you can't work as a nurse practitioner in a dermatology practice within 10 miles from the primary practice location. It will give you options if you can really narrow it down to what you're doing. And maybe you're an FMP, you're working in primary care, then you want to leave the option open to do maybe work in an ED or urgent care or something like that. So you want to make certain that it's very specific to what you're doing, which will then give you other opportunities, assuming you don't want to leave the area where you're working. So the last thing obviously is the geographic radius. So any non-compete is going to prohibit the NP from working in a specific geographic radius. So somewhere between 5 to 20 miles. It really kind of depends upon the setting. If you're in a very rural environment where there's only the one city and the next city is 50 miles away, well, a larger non-compete would probably be considered more reasonable, whereas if you were in New York City, 1 mile could knock out hundreds of opportunities, and so anything more than that might be considered unreasonable. But if you're just in the average kind of normal suburb or city, somewhere between 5 to 15 to 20 miles would be considered reasonable. Obviously, you want to push so that it only applies to one location. So let's say you're an NP and you're working for a pediatric office, and they want you to work in multiple locations. Well, you want to make certain that it only applies to the locations that you're working at, no more than 2 of those. What you don't want to do is sign a non-compete that states you can't work within 10 miles of every location owned by the company. So, the corporate practice of medicine and some of these big franchises kind of continues to proliferate throughout the country. And so you may be in a city where your employer has 15 locations, and so you don't want 10 miles from 15 locations to apply. You want 10 miles from your location to apply. So really look at the scope of how many locations it applies to, and then obviously how far it is. A good way of explaining this is, if you are someone that has ties to a community, so you have family there, kids in school, grew up in the area, it's extremely important that you stay there after the contract ends. You absolutely cannot sign a contract which is going to effectively force you to move from the location for a period of time. This can be the absolute number one thing that we negotiate for some nurse practitioners. Now, there are others who move in for the job and then have absolutely no ties to an area, and the non-compete has no effect on whether they care about the job or not. But for those of you where it is important, you absolutely need to pay attention to the language and make certain that it doesn't, force you to leave the area if you don't want to. So that's a little breakdown on non-competes for nurse practitioners. If you have any questions, you can always call us at the phone number listed below in the description, or reach us through our website, chellelaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate it. Thanks.